Hello, my name is Rachel Rolfs, and I'm with the law offices of Rachel Rolfs and Associates. We're a family law firm in Tacoma, Washington, serving Pierce, Thurston, and South King counties in the areas of family law. The purpose of this video is to help you complete your petition for divorce/dissolution. This form is only good in Washington state, so if you are divorcing in a state other than Washington, you need to find the correct forms for your state. Also, this video is not intended to act as legal advice. It's intended to help you properly complete the forms, but the advice of an attorney is highly recommended to ensure you know your rights and obligations. I can tell you what belongs in each section of the form, but I cannot tell you the ramifications of those sections. I will point some of the more obvious or more common ones out here and there, and when I do so, I highly recommend you talk to someone before you file them yourself. So let's go ahead and get started. What you're going to do is go to Google. So we're at Google. We are going to type www.courts.wa.gov/forms/ enter. You're going to go to the court forms page. We're going to scroll down to family law. We're going to come down here to divorce, and we're going to click on divorce dissolution. And the form that we're going to do today is the petition for divorce. It is required for every divorce in Washington state, whether you have children or no children, whether you have property and debts, whether you don't, you need this form. There are, of course, other forms. As you can see from this page, there are a lot of other forms that you might need for your divorce depending on what you have going on. Again, today we're just dealing with this petition. So what you can do right here is you can click on W for Word, or you can click on a PDF. I'm going to go ahead and use Word so I can kind of highlight the areas. If you use Word, of course, you can make changes to the documents and print them out, or even in some counties just sign and PDF. So I'm going to open the document. I'm going to enable editing, and here we go. So I'm going to kind of run quickly just through some of the spots. Other spots I'm going to talk more deeply about. But you need to fill in every section. Everywhere that there's a line, every section that has check boxes, you have to check at least one box in each section, and you need to fill out every line. This first line here, you're going to type in the county in which you are filing your divorce, whether it's Pierce, Kitsap, King, etc. Here's for the case number. You're not going to get your case number before you file this document. Filing this document is when you get issued the case number. So normally the court's going to fill that in, but when you do your other documents after this one, you're going to need to refer to that number and add it into all your future documents. Petitioner, I'm going to assume for today that you are the petitioner because you're the one filling out this form, and generally that's how it works. That also means the petitioner is the person who's going to actually file this form and pay the filing fee. Respondent would be the other party, so generally not you. In section 1, you're going to fill out the petitioner in which you, again, petitioner, reside. So county here, state here. You're going to fill out the county and state in which the respondent lives. Section 2, information about the marriage. You're going to fill out the date you were married, the city and state in which you were married, and then these couple of kind of extra sections right here. If you were in a domestic partnership or a civil union prior to getting married, you're going to want to fill that information in here. If you were in a serious marriage-like relationship, which we call a committed intimate relationship, if you were in one of those before the marriage, you can fill that information in here. There are some legal ramifications to these sections. So if you have any of those, or especially this committed intimate relationship one, you may want to chat with an attorney about what all that means and how that might reflect what you should be doing in other portions of this document. In addition to those sections, and whether you have been in a committed intimate relationship or domestic partnership or not, you do need to check one of these two boxes. So we currently live in the same household, check that if that's the case. Or if you are no longer living together, you're going to check this box, and you're going to say the date in which you stopped residing together. Section 3, this marriage is irretrievably broken. So you need to determine in this section the date that your marital community ended on. Normally, someone chooses one of these dates. So when you guys moved into a separate household, when you separated your assets and debts, or you agreed the marital community ended. So you can check this box if you have one of those dates and put in the date that those things happen, and then check any of these that apply. You can check more than one. If you believe that your marital community hasn't ended yet, for example, if you're still living together, your finances are still combined, you guys have just decided to do this, or maybe just one of you has just decided to do this, then you may select the date this petition is filed as the end of that date. The date that you choose here, the date that the marital community ends, is the date that the court often, they don't have to, but they often will use that as a date for valuing assets and debts and dividing assets and debts. There's kind of a general assumption that after that date, anything that you earn is yours, anything respondent owns is theirs. Same with debts incurred. It's not a done deal. The court can still kind of do whatever they want on that, but there is a little bit of kind of a presumption as you begin. So keep that in mind as you fill this out. If you have questions or concerns about that, you should talk to an attorney. Section 4 is jurisdiction over the spouses. The court has to have jurisdiction over the marriage and over both of you to issue a divorce. The most common right here is to check this box saying the court has personal jurisdiction over the respondent. And then you check any of these boxes that apply. So you can check one or all three. If you cannot check one of these boxes, you probably want to chat with an attorney, because it means Washington State may not be able to do anything other than just grant a divorce. If the court has jurisdiction over you but not the respondent, there are things that they cannot do. If the court does not have personal jurisdiction over the respondent, you would check this box. But again, I recommend you chat with an attorney to make sure you're not filing this in vain. Section 5, is one of the spouses pregnant? Yes or no? Who's pregnant? If someone is pregnant, there's some information here. Again, I can't go into giving you legal advice, but I recommend you chat with an attorney about that. And I keep saying chat with an attorney. There are often pro bono resources. There's also the court facilitator, at least in Pierce County we have one. I don't know if all the counties have that, but there are some other options. So I'm kind of using speak with an attorney as get more information, okay? Children of the marriage, section 6. If you have no children together that are still dependent, you're going to check this box. But please note that this says dependent. It doesn't say under the age of 18. So this section relates to dependency. If you have a 19-year-old who's in college or a 21-year-old who's in college and you're paying for their living expenses and they're not working, that child can still be considered a dependent. And so if you believe that you want to be financially responsible and that the other party should also be financially responsible for that child still, you don't want to check this box. So this is all the kids are like grown and gone. The second box, you have the following children together who are still dependent. You'll check that box if you have children, and you'll list the children's names and ages. Also, if you have, a 28-year-old adult child who is still dependent on you for whatever reason, you can put that adult child in here as well. Section A, children's homes. If at any time during the past 5 years have any of the children lived on an Indian reservation outside Washington State in a foreign country or with anyone who's not a party. If no, check no, and you can skip to section B. If yes, you're going to need to fill all of this out. So the dates, which children, who they lived with, and in which state, Indian reservation, or foreign country. Section B, other people with a legal right to spend time with a child. If there's a minor guardianship case, if there's a third-party visitation case, if there's a non-parental custody case, those are old now, but some of them are still hanging out there. If there are any of those things pertaining to the children where someone else has a right to visitation or to custody of your child, you need to put that information here, the name of the person and the children that it pertains to. Similarly to that section, section C is other court cases involving a child. So in this case, it could be a previous divorce that was filed that wasn't finished. It could be a protection order if there's a domestic violence protection order, an anti-harassment order that has the children listed. If there's been a CPS case, if there's been a CPS, an actual dependency case, not just CPS involvement. If a case was filed with the court, that's a dependency, you would put that in. Any truancy, any court cases regarding the child or children goes here. So the type of case, county and state of that case, case number and year, and what children's it pertained to. Section 7, jurisdiction over the children. So if you have no dependent, and again, this refers to dependent, not 18, so ignore 18 still. So if you have no children together who are still dependent, you just check no and you move on to section 8. And if you do have dependent children, then you're going to want to check this box because you've got to do a parenting plan. And then the most common boxes to check here are home state jurisdiction. That's the most common box. Almost all of you are going to check this home state jurisdiction box, but I want to run through the others just in case. So exclusive continuing jurisdiction usually doesn't apply in an initial divorce because it's usually the first time you've been there for a parenting plan with the children. But if there has been something else, like if there's a minor guardianship or something pertaining to the children, then this could be the section you want. And you can check all of these that apply. So if more than one applies, just check them all. Home state jurisdiction is where the children have lived in Washington with a parent or someone acting as parent for at least 6 months before this case was filed, or if they're less than 6 months old, that they've been here since birth. So that's the most common one. You check that box, you put in the children's names, you're going to check this box, and you're going to check this box. Watch your boxes. People always forget to check them. It can cause problems, so be careful. If the children have been here for 6 months, but like they were gone for a month on vacation or something, you would check this box as well. If the children are no longer in Washington, if they've like very recently moved out of Washington within the last 6 months, so if they lived here and then they left, like say one of the parents took them and moved off to Arizona or something, if it was less than 6 months ago, you check this box, put in their names because they were here sometime in the last 6 months. And of course, one of the parents still has to live here in Washington for that box. No home state or home state decline. This is a pretty rare clause here. Sometimes it happens with military families where both parents are military, things like that. You can kind of stumble your way through there if you need to. Other state declined. This is also a very uncommon one, but read through it and see if it applies in any way. Temporary emergency jurisdiction. This one's also really uncommon, but if you need a divorce and you've got an emergency with the children and the children are here now in Washington, but none of the other sections apply to give Washington jurisdiction, you can ask Washington to take temporary emergency jurisdiction to protect the children. Occasionally, if the court does not have jurisdiction over the children, every once in a while someone will still file a divorce here and just deal with the parenting plan in another state. It's pretty rare, but if that's your case, then you would just say the court can't do a parenting plan. Section 8, parenting plan. So the parenting plan section, you'll note, talks about under 18 years old because the parenting plan, unlike the other sections here, end when the child is 18. So this section may be a little different than dependent section. So if you have no children under 18, you check this box. If you have children under 18, then you're going to check this box. So you're going to ask for a parenting plan, and then you need to decide if you're going to file that parenting plan at the same time as this petition or if you're going to file the parenting plan later, and check whichever appropriate box. For several reasons, I always recommend filing it at the same time, but getting into the why of that would be a really long conversation. Again, if the court cannot approve a parenting plan for whatever reason, then just say the court doesn't have jurisdiction. Child support. So child support, the court requires you to do child support. If you're coming into this and you guys have an agreement and you've agreed to no child support, the court still has to set a child support order. That child support might be 0, but they still need to set it. So if you don't have any children together who are still dependent, and again, this is the dependent, so it doesn't matter if they're over 18, this is dependent. Select that box if there are no dependents. If there are dependents, you're going to select either this court order box or this administrative order box. So if you don't have a Division of Child Support administrative order already, then you're going to check this box. If you have an administrative Division of Child Support order and you don't like that order and you want the court to do a new order, you can also check this box. You only want to check the administrative order box instead of the court order box if you already have an administrative order and you just want that one to stay in place. If that's the case, if you like your administrative order of child support and don't want it to change, then you check this box and you do not check the court order box. So back up here, if you do the court order box, you're also going to, as a part of that, ask the court to order your spouse to pay his or her proportional share of things. So if the children are young and you've got daycare, you're probably going to want to check the daycare box. Normally the court's going to want you guys to split that cost. If it's going to be a long distance parenting plan, you've got airfare or train or whatever for the children to visit the other parent, you're probably going to want to share the long distance transportation expenses. Normally the court will want you to share those. Education expenses, this is normally like private school tuition. So often it doesn't apply. Some people make this nice and broad to include like school supplies and things like that. If you want it to be broad, just add on to the end here and kind of say what exactly you want that to include. Post-secondary college, if the children are getting near to college age, or even if they're not actually, because you can just reserve it and deal with it later. If you think that you might want you and the other parent to be required to help pay for their college, you're going to want to check the post-secondary box. And then other child-related expenses. A really common one that people like to put in here are extracurricular expenses, clubs, programs, educational camps, things like that. So sometimes people will add those in here, and of course check the box. Also, tax exemptions. The court can determine how the tax exemptions are divided. So it's very common to check this box and to say how you want the tax exemptions to be divided. So the most common way, if you've got one child, is that you guys alternate years. One of you claim the child in even tax years and the other one in odd tax years. If you have two children, a common way to do it is each of you claim one child every year. And then when only one child is left claimable, then you alternate years on that child. Again, if you're doing this administrative order, if you already have an administrative order of child support and you want to keep it, then you check this box. You need to fill in your DCS case numbers. I also recommend taking a copy of that order and filing it with the court so the court can see it. The Division of Child Support orders don't cover the tax issues or post-secondary and these things up here. So if you want to keep your administrative order, but you want to deal with tax exemptions and post-secondary, you can add those here. So if you want to do that, check the box and say you want how you want the tax exemptions done, and if you want to add in post-secondary, check the box there. Section 10, children from other relationships. If neither of you have any other children from other relationships, and again, this is dependent, so any dependent children or dependent adults essentially, you would check this box. If either of you do have dependent children, you're going to fill out whichever one of you or both of you. So this is I for the petitioner, check the box, put your other children, and this is respondent, check the box, put the other children. Section 11, written agreements. This is pretty uncommon. If you have a prenuptial agreement, you would do this, a separation contract, a community property agreement. If you have any of those, you would say yes. If you don't, you say no. If you say yes, you're going to say the type of the agreement and the date of the agreement, and then you're going to say whether you want the court to enforce that agreement. If you say you don't want the court to enforce that agreement, you're going to say why you don't think that they should. Section 12, real property. You have several boxes, you have choices here, and this is kind of going to go through the next few sections. So real property is land or home. It does not include mobile homes that are on property that you do not own. It does include mobile homes on property that you do own. So if neither spouse owns any real property, then check that box. If you do own real property, if either of you own real property, and let me note, for all of this property and debt, people think when I say, do you have any property? They'll say no. And then I'll ask if their spouse does, and they'll say yes. So when I say any property, this is property of yours or property of your spouse's. It doesn't matter whose name it's in. It doesn't matter if it's just in one of your names. It's all community property if it was acquired during the marriage. And sometimes property acquired before the marriage can also be community. But even if it isn't, These next few sections are going to include all property, separate or community. So even if you had it before the marriage and they have no right to it and it's in your name, you still need to list it here. This needs to be very broad, okay? So if you have a Section 11 agreement, that's the written agreement. If you have a written agreement and you want it to be done, you can do Section 11. I'm going to start glossing over that in these other sections. So I'll just say if you have a Section 11 agreement, check the box. If you don't have Section 11 agreement and you do have real property, then here are your other choices. I'm going to assume for the rest of this that the court does have jurisdiction to divide the real property. If the court has jurisdiction over the marriage, over the petitioner, and over the respondent, then they're generally going to have jurisdiction to divide the real property. It doesn't matter what state the property is in. So I'm going to mostly ignore these no jurisdiction portions because they're pretty rare. So that leaves us with these. You can tell the court how you want the property to be divided, or if you don't know, if you're at the beginning of this process and you're just not sure what you want yet and you're just trying to get the process started, you can say that the court's going to do it as the court decides. If you do that, and this is going to also follow for the next several sections, anytime you say, I want the court to decide, that still means that you can reach an agreement at any time before trial. It just means that you don't know how you want it to be right now. So this provision really should say as the court decides or as we agree before the court makes that decision. So if you know what you want, you're going to check this box and you're going to type in what you want. Now, this isn't the best kind of format to fill this in. You do need the property address, you do need the tax parcel number, but sometimes you're not just giving the property to one of the parties. Sometimes you're going to sell the property. Sometimes you're going to give it to one of the parties, but that party is going to pay the other party half of the net equity or something. So what you can do is you can fill in the address, and then you can, under that, you can say something like petitioner to retain the property and pay respondent 50% of the net equity determined by appraisal, or something like that. You can put in whatever you want to do. You can put in as much detail as you want in here. What I'm going to say about the next several sections also are, if you're going to default, if you're doing this and you're going to serve the other party, or you're going to have the other party served because you can't serve them yourself, and you think that they're not going to respond ever, you can get a default. In order to get a default, though, your final orders on the default are going to match what you put in this petition. So if you say you want the court to do it as the court decides later, then when you default, you can't tell the court how this is. They haven't been put on notice of what you're asking for. So if you think you might default, you want to be really descriptive and really clear in each of these property and debt sections. If you think they're going to respond and come to the table, then you can absolutely do, as the court decides, and work that out later when you have more information. So in any event, you can feel free, put in the information that the court requires, but put in more information if it's needed to tell the court what you want. Another option here would be to fill in the address and say property to be sold with net proceeds divided evenly. Something like that. And you can put in a bunch of other provisions like what real estate agent you want to use and things like that. So just be descriptive. The more you can put in here, the better, if you know what you want. If you don't know what you want, then nice and easy, just check this box. Personal property. Personal property includes everything other than real property that is worth value. So this is vehicles, it's retirement accounts, it's bank accounts, it's any big art pieces. It can be, any really expensive jewelry. Generally, you don't want to get into like small things on here just because it's really cumbersome. So I usually kind of tell people do anything more than like $2,500 or so. Like generally, you're not going to do couches and dressers, but some people do. If you think there's going to be a big argument over them, then by all means put them in. So if you say here, we've already divided the property fairly, you can do that, but if you can't show that you each knew what the other one had, like if you do that and then later the other spouse comes and is like, hey, I just found out you had $300,000 in a retirement account and I didn't know anything about it and now I want half, the court can give them half. So this is a dangerous section if you have any significant assets. If all you have are vehicles and, you know, some small bank accounts and things, that might make sense, but generally you want to be more detailed than that. This next box is if you have a Section 11 agreement, as we've discussed. If you're going to set out the personal property, you're going to do it similar to how we talked about the real property up there. So again, this petitioner respondent section isn't great because sometimes you have like joint Chase bank account ending in 1234. You're not going to want to put full account numbers on here, just use the last four. This is a public document, so you don't want to put in anything that you don't want to be out there. You can say joint Chase bank account ending in 1234 is going to go to petitioner. You might want to, again, just like in the real property section, say respondent to sign all documents to remove their name from the account within 30 days, something like that. So you can kind of do that. You're going to do like 2012 Subaru Outback. And I don't want to have you sit here and watch me struggle to put in check boxes, but you know, do better than I did there. So, but do check the boxes over here as required. If you're going to do, let's say, petitioner's Fidelity 401k to be divided evenly as of the date of separation, or you can say as of, you know, X date, fill in whatever date that you want to kind of divide that asset as of. Just a heads up, if some retirement accounts, including 401ks, need what's called a qualified domestic relations order to divide them. That's an additional document. There isn't a form document. Sometimes the plan will have one, but just know if you're going to divide a retirement account, you might need this extra plan that is not super fun or easy to do. So heads up there. Pensions, you know, you want to include pensions, respondent's pension, respondent's maybe TERS, Plan 3, things like that. Check who gets it, or maybe it's going to be divided. Again, you would need a separate order dividing those. So just put everything in here. All the things. Don't forget anything that is important to you. Again, you don't have to do couches and things like that unless you really think that you need to. If you have no idea what's out there, if you don't know what there is, so you don't know enough to know what you want, again, just check this box and you can figure it out later. And if you don't, then the court will make that decision for you. On to debts. Similar rules to the last two sections. You want to be really broad on this. You can say you're not aware of any debts, but you do have the choice through the process to do discovery and find out if there are any debts. So if you say you're not aware of any debts and that's the only thing that you check, then if there are any debts out there, the court can still deal with those later. This is a really common provision. I asked the court to order each spouse to be responsible for debts made after the date of separation. That's very common. You can go ahead and check that box if that's what you think is appropriate. There's the Section 11 agreement. You can check this box to be responsible for debts incurred after date of separation, and you can also check this box to do the following orders about debt. So the one after separation kind of covers anything once you guys stop living together and handling your finances together. Maybe you don't know what the other party has done. So you check that box to cover those things, and then you can do this box and this section for the things that you do know of that you had during the marriage. So for this section, you can say each spouse is responsible for debts that are now only in their name, and that might cover the things that you have, but it might not. If you've got any joint credit card debt, if you have a joint mortgage, any of those things, that may not cover it. So any of those you're still going to want to set forth. So you can check this box and you can check this box also. So kind of just check any boxes that apply to your situation in these sections. So here you're going to put the debt amount, the creditor. What this doesn't say to do is say what it's for. I like to say what it's for. So I'd be like Chase Mortgage, last four of the account number, who should pay it. Now this one, again, if you're doing a mortgage and you're like selling the house, so if petitioner's keeping the house, then you're probably going to say Chase Mortgage and say petitioner's keeping it. But let's say you're selling the house. Chase Mortgage, you could say Chase Mortgage payments until the home is sold. Then the mortgage shall be paid off by the sale proceeds. So again, you can get kind of creative and say what you need to say in these. So don't forget the mortgage, don't forget car payments, any debts that are owed to anyone. These aren't monthly debts. This isn't like utilities. Unless you owe a back debt on your utilities, then that's going to be included. And then again, if you have no idea what's out there, you don't know what you want yet, divide as the court decides and you can work it out later. Spousal support. So spousal maintenance, you can say it's not needed if no one needs any maintenance. If spousal support is needed, you're going to fill in this section. So this section, you're going to say who has the ability to pay and should pay. So if petitioner wants respondent to pay, you're going to check the respondent box and say respondent has the ability to pay and should pay. You can do as decided by the court if you don't know how much you want and for how long. Or if you know what you want, you check this box. You put in how much money every month you are seeking for maintenance, and then you put the end date of it there. Again, if you've got a Section 11 agreement, then you would check that box. Fees and costs. If you're going to pay your own fees and costs, attorney fees if you have any, filing fees, etc. If you're okay paying your own, no request. If you want some help with attorney fees or filing fees, the filing fee for filing this divorce is somewhere around $315. I think it differs a little bit county by county with different fees and charges. Then you would check this box if you want help with that. These next three sections are 17, 18, and two sections, 17 and 18. Protection order and restraining order. They're both very similar to each other. So if you don't want a protection order, you say no. If you do want a protection order, you say yes. If you need a protection order now, you can always go to the clerk's office or contact the court or even the police and tell them that you need a protection order. This does not automatically give you a protection order. You have to say if you want one, but this doesn't give you one. You have to go take separate action to do that. If you want a protection order, or if you don't want one, either way, if there's already a protection order, you want to fill out this section, the court that issued the order, the case number, and the expiration date, and of course, check the box. Section 18 is very similar. Restraining order. If you don't want a restraining order, say no. If you do want a restraining order, then you've got all this to fill out. So if you want the restraining order, you can say what kind of order. There's do not disturb, stay away, do not hurt or threaten. You can also ask that weapons be prohibited and surrendered. So just kind of read through those sections and see what you need. I think most of them are pretty self-explanatory. And again, the restraining order is not automatic. If you want a restraining order, you need to file for that with the court. It's a little different than a protection order. Usually you would do this through this same case. A protection order is sometimes through a different case depending on how your county handles it. Section 19 is name change. If nobody wants their name changed, then you click the no request. Normally, again, since this is the petition and it's only normally signed by the petitioner, put in here, change the petitioner's name to first, middle, last. If you're doing a joint petition, if the respondent is going to sign this petition, you can add in here to change the respondent's name. So you just kind of copy it, just add a section. You don't want to mess with these forms. I probably shouldn't even be showing you this, but I think it's important just to get it in here if you're having it, and my formatting is not going to work right, and I don't want to spend your time on that. Oh, I guess it worked. Kind of do that and then just change, respondent's name to, and add that in and check the box. Section 20 is other requests. So if you filled out the property and assets and debts sections really detailed, like I kind of showed you to do, and make that as long and as big as you need it to be, you usually don't have anything to put here. But if there is some other outstanding thing that you couldn't quite address up in there, you can put that here in section 20. Okay, so then signing. Petitioner is going to be city and state where you are signing. So if you live in Seattle but you're signing in Tacoma, that's going to be Tacoma, Washington. The date that you are signing, then petitioner signs here and prints name here. Lawyer, if there are lawyers. And then this section is where if you guys have an agreement, you agree on everything, and the respondent is going to join in the petition. That saves you a little bit of paperwork. It saves you some process. So if the respondent agrees to this, they're going to check this box. They're going to put their name here. And then they're going to say if they want to be notified about court's hearings or decisions in this case. Normally, if you've done a full-on petition, you have all the assets and all the debts and the maintenance, if you set out everything how it's supposed to be and you both agree on it and it's real clear, normally it's okay for the respondent to say they don't need to be notified, because at that point your final orders are going to exactly mimic this petition. But if you have children and there's a parenting plan that you haven't both signed, or child support that you guys haven't both signed, or if you haven't figured out all the details on here, then the respondent is probably going to want to be notified about any hearings. Just a heads up, at least in Pierce County, this notification, if they ask for this notification, the petitioner can't do it. The petitioner has to have someone else send the notice, and then that person has to file a declaration essentially saying that they gave the required notice. So just be aware of that. And then if respondent signing this part, then respondent signs here and prints their name here and dates here, and then you are done with your document. So I hope that that was helpful. I know it got a little bit long, but I hope it gets you on your way. I, again, strongly encourage you to speak with an attorney in the county in which you're filing to answer any legal questions you may have, and also just to make sure that you understand your rights. Obviously, again, this wasn't legal advice. It's more just kind of how the document works and what the document is expecting you to fill in each section. If your divorce is in Pierce, Thurston, or South King County, you're welcome to contact my office. Our number is 253-572-5845, extension 1. So thanks so much. Have a great day.